Hello and welcome, everybody. I appreciate your time. My name is Dana Sparks. I am the broker of Maximum One Greater Atlanta and the director of the Real Estate Academy of America, which is the school offering this course for CE credit. This class does satisfy the new Georgia Real Estate Commission's requirement as of July 1st, 2025 of broker CE credit. So I welcome everybody, and my goal in any class is that at the end of the class, the CE credit is just a bonus. Specifically with this class, because I know you guys are here because you all need that broker CE credit. So my goal is truly that at the end of this class, you will really have learned something that definitely will help your business as a broker, a qualifying broker, a managing broker, or even just your business interacting with the public with a broker's license and as an agent. I also hope that my goal of teaching every class is that the 3 hours goes by quickly and you wish we were here longer. This class is on earnest money and could go on for hours and hours and hours, but I will do my best to just highlight salient points to really keep in mind. Some of you experienced agents, hopefully you know all this stuff and it'll just be a reminder. If you are a new licensee, hopefully you already know this stuff and it'll be a reminder. As we go through the class, you will see I do have some tips and tricks and hints for managing and qualifying brokers running their brokerage and doing compliance regarding handling of earnest money. Additionally, for every class, and this class specifically, I pray that I am a vessel of God and that I bless you and your time being here, and that I do reflect His light. And at the end of this 3 hours, you will leave in a better place than you came, whether that feeling confident in yourself or feeling confident to bless others with your real estate license. So that being said, let's dive in. I'm already, well, let me share my screen again. Here we go. I do have the chat open. So if you need to have interact with me, please do so with the chat. And we'll get started. Put my glasses on so I can see. Broker's Guide to Earnest Money and the Georgia Association of Realtors, or GAR Contract. This is a broker and a salesperson CE credit. Again, my name is Dana Sparks. There is my contact information and there is the school information. This is the notice to students is the school is GREC school number 6915. We renew next year. This is an approved virtual remote broadcast of an approved in-class course. No homework, no tests. The way we do attendance is via the chat function. If you have already done so, you do not need to do it again. But if you have not, I need you to type in your name, your Georgia real estate license number, your email, and your phone number. We ask for your email and your phone number, not to spam you, but in case we have issues with recording the CE credits, we can get in touch with you. So I'm going to ask you to do that 3 times now, when we come back from break and before you leave. Additionally, I will ask questions. Some are rhetorical, but some I will prompt you to put your answer in the chat. And I do that so that we can demonstrate that you are still sitting here at your computer paying attention and you didn't just turn it on and walk away. There was a question in the chat. How do you know if it's a broker approved class? You have to ask the instructor or the school. There is no consistent way to look and see. There is a place on GREC. If you go to GREC's website and go to the education, you can see what schools offer broker CE classes, but there's no list of broker categorized CE classes. So again, for any class, you are just going to have to ask the instructor and the school.
No, no, the question was, how do you like, what's the list of the name of the classes? Like, you know, that's what I'm asking.
I don't understand what you're asking.
So, like, this class is in regards to earnest money and stuff. So, like, the next class, what would be like a list of classes that are approved?
There is no list. You have to just, if you see a class you want to take, you have to ask the instructor if it's approved for broker category CE or just salesperson CE. There is no list.
Okay. All right. Thank you. Because that's why I was just
Hopefully,
looking to make sure I'm not duplicating some of my classes.
yeah, well, you would just check with the GREC course number. So hopefully it might have broker in the name of the class, but not necessarily. So for any class, you can only get credit for any one class once every 12 months. It's not on the topic. You can take other classes on earnest money. You cannot get credit again for this course number. That's like contracts classes too. You can take 30 hours of contracts classes. You just won't get credit within 12 months for a specific course number. So that's what you want to pay attention to. And there is no recruiting. This is for our school, the Real Estate Academy of America, the calendar of our classes. And this class does have a handout, and it is on the school's website on the tab Course Handouts and Videos. I'll show you how to get that when we come back from break. Okay, no homework and no tests, but I do have a quiz, but we're going to take it together. So type in the chat just a T or an F. And in the interest of time, if I've already given the answer, go ahead and type your answer anyway, again, because that demonstrates your attendance. So here is question number 1. A broker may hold earnest money at the branch until directed to deposit by the agent or client. True or false? Type in the chat, T or F. You guys are good. The answer is false. Agents who own rental property may hold security deposits in their own business bank account. True or false? Agents who own rental property. Yes. False. Oh, I already gave the answer to the second one. False. It cannot. If a broker allows an agent to hold a security deposit, it must be in a trust account. We'll cover that later. I already gave you the answer to the third one. And I hate it because I always trick everybody on that one. Licensees shall place earnest money into the custody of their broker within 3 business days. That is false. I typically get true when I ask that quiz question. You'll see what license law says regarding that as we go through the class. A broker who disperses earnest money contrary to the terms of a contract can be deemed incompetent by the commission. True or false? Yes, that one is true. All right, 2 more quiz questions. A broker may automatically transfer earnest money from a terminated contract to a new contract. True or false? All right, you guys are getting this one correct, false. But when I get to the discussion of this, I'd be curious if you guys are actually the steps you're taking to take care of this. Earnest money is required for a contract to be binding. True or false? You guys are good. The answer is false. There must be consideration for a contract to be actually enforceable, but earnest money is not the consideration of our contracts. All right, good job, everybody. Today's class, we are going to review Georgia license laws regarding earnest money and escrow funds, talk about transferring earnest money from one contract to another, talk about the Georgia Association of Realtors contract language regarding earnest money, and discuss a broker's guide to educate their agents on how to discuss earnest money handling with their clients. There is a lot of issues where what your agents say to a buyer regarding earnest money about it being protected and safe and what may actually happen. There could be a difference between those. And so today I'm going to discuss some different issues to help your agents have those discussions with their clients to not lose the confidence of their clients. Disbursing earnest money upon a contract termination, a 10-day letter, or intent to interplead. All right. We are going to start off with a brief review of license law. I'm not going to go in depth because the Georgia Real Estate Commission does require that everybody take a license law class. So this is covered in the license law class. But for this section, the term escrow account and trust account shall be interchangeable. We will use the term trust in the following slides rather than trust or escrow to reduce the text. And these laws also apply to any agents who hold escrow accounts for investment properties too. So, Georgia Code 434020, handling escrow funds. Each broker who accepts trust funds shall maintain a separate federally insured bank checking account, which shall be designated as a trust account where all funds are held on behalf of another person shall be deposited. The account shall not be subject to attachment or garnishment. Some of you, if you are a broker, qualified broker, managing broker, but some of you may not know. Not every bank has a trust account. It's not something that you just say, oh, it's a trust account. There are certain banks that will not allow trust accounts. And the key is that account cannot be subject to any liens on it should the person or the business get in trouble. In 2015, the Senate Bill 95 changed the definition. So it doesn't have to be a federally insured bank. It could be any institution to encompass credit unions, buildings and loans, so forth and so on. And they changed it. It doesn't have to specifically be a trust account. It can be any account as long as it is federally insured. Brokers shall notify GREC of the name of the bank in which the trust account is maintained and also the number of the account or however they name that account. And GREC has 100% full authority and authorization to examine any and all trust accounts at any time upon reasonable cause and during each renewal period. Now, GREC is not authorized to examine any particular broker's operating accounts, commission accounts, so forth and so on. Just trust accounts. Why? Well, because in that trust account, it is a public person's money. It is somebody else's money, not the broker's money that they can use for their bills or commissions or so forth and so on. And one of GREC's main responsibilities is protecting the public. A broker may have more than one trust account, but GREC just has to be advised of it. A broker shall not be entitled to any part of the trust funds paid to the broker in connection with any real estate transaction as part or all of the broker's commission or fee until that transaction has been closed or terminated. Any licensee acting in the capacity of principal, that means any agent, if you hold a real estate license in Georgia, then you are an licensee. And if you are principal, that means buyer, seller, landlord, tenant, investor. If you are the principal in the sale or purchase or of real estate that you own, you have to deposit those trust funds, earnest money, security deposits if it's a rental house, in the same manner. And you are not entitled to those funds again until the sale closes or if it's terminated. Licensees who receive trust funds on properties they own must deposit those funds into a trust account maintained by the broker with whom their licenses are affiliated, or in a designated trust account approved by that broker. I'm just going to pause here for a minute. There are many, many brokers who do not allow their agents to have a trust account to hold security deposits for any rental properties they own. Why? Well, the broker has responsibility and liability for that trust account, but the broker is not necessarily on that account or has access to that account. You'll see there's a couple more license laws in a second I'm going to touch on, but many brokers don't allow their agents to hold trust accounts for that reason. But if you have agents or you are an agent and you have investment properties with tenants, let's say, and you're going to hold a security deposit, you either have to put it in your broker's trust account or you're going to have to hire a property management company or not take a security deposit. If a broker does allow an agent to have a trust account, then a couple things. Number one, that trust account must be approved and registered with GREC. The broker is the only one who can do that, not the agent in and of themselves. And if a broker allows an agent to have a trust account, the broker does register it with GREC. License law says, and I think I have it as a slide in a minute, you still cannot do that if the title of that property, you have to be the sole person on title of that property. So that was a lot to take in. This is what I just said. If the broker approves of a licensee holding funds in a trust account owned by the licensee, the broker shall assure the account is designated as a trust and notify GREC of the name of the bank, account number, so forth and so on. The licensee who owns such account shall maintain records on the account as are same that are required for brokers in maintaining their trust accounts. The licensee who owns account shall provide such licensee's broker at least minimum quarterly, and the broker can require it more often, a written reconciliation statement comparing the licensee's total trust liability with the reconciled balance of the licensee's trust account. For any trust account, whether it be the broker's trust account or an agent's trust account, it has to balance out $0 to $0. Money in, public money out. The public money out must match up with a closing or a termination. Now, those were all Georgia code in our Georgia law books. GREC also has rules regarding trust money because these are still part of license laws, but because this is a little bit different section, these are GREC rules versus Georgia code, you will notice some repetition of the content. Of the concepts. Brokers again may maintain multiple trust accounts. You have to notify GREC within 1 month of opening each account. So broker point of practice. If your brokerage currently does not hold trust money, you don't hold earnest money, for whatever reason, there is a contract and you have to hold earnest money, you can do it. You're going to have to go open up a trust account. You can hold earnest money, security deposit, so forth and so on. And then you have 30 days to notify GREC of that trust account. Licensees shall place all cash checks or other items of value received into the custody of their broker holding their license as soon after receipt as is practically possible. So that is the license law. And oops, I've got to um a broker may have a policy regarding a certain number of business days, calendar days, whatever, but the law says as soon after receipt as is practically possible. So, sort of vague, a little bit relatively vague, but again, here we go. The a broker can make that a little bit more specific. When acting as a principal, again, buyer, seller, landlord, tenant, in the sale of interest of real estate owned by the licensee, the same applies. You shall place all cash checks, or other items of value received into the custody of the broker holding their license as soon after receipt as practically possible. So if you have an agent that's selling their own home, they cannot hold earnest money in their own account. If you have an agent that has a rental property, they cannot hold security deposits in their own account. Now, brokers. License law says the broker holding funds shall promptly deposit those funds in their trust account and shall make appropriate arrangement for the safekeeping of other items of value. Okay, before I go on to the next section, what does that mean? I have a lot of agents and brokers that sometimes get confused that the broker has to deposit those funds within a certain number of days. Why is there that confusion? Well, the GAR, this class is focusing on the Georgia Association of Realtors contract. In the RE forms contract, the timing is a little different, but in the GAR contract, it says that the broker is required to deposit earnest money within 5 banking days after receiving the full contract or receipt of the earnest money. So the contract specifies or defines what promptly is. License law, again, for brokers is a little bit more general by saying promptly deposit. The contract is what specifies the number of days. I'm going to talk about that a little bit later too when we get to the contract for actual in working purposes for sending notices, so forth and so on. But hang on, we'll get to that a little bit later. Now, the next thing for license law, if a broker's trust account is interest bearing, the broker shall obtain written agreement by the parties indicating to whom the broker shall pay any interest prior to making that deposit in the account. So, broker point of practice. The GAR contract, and actually the RE forms contract as well, but I'm going to focus on GAR, does have that pre-printed in the purchase and sale agreements that if a broker's escrow account does bear interest, that the broker is keeping the interest. Brokers or agents, if you are a party to a contract that is not a GAR contract, if the holder of the earnest money, if that trust account does bear interest, you may have to add this verbiage to your contract so that you don't violate license law. So here is where it says, as I mentioned, if you are on a GAR contract, this is the purchase and sale agreement F201 under paragraph B6. GAR has us protected. Thank you, GAR, for not allowing us to violate license law. It says, holder, excuse me, earnest money shall be deposited in the holder's escrow or trust account. Holder being permitted to retain the interest if the account is interest bearing. So GAR has that pre-printed for us to stay in compliance. A broker can put in their own money in a trust account, but it's just to avoid any fees because banks, even though they do designate an account as a trust account, if there is a bounce check or below a certain balance, the banks will still charge fees. Well, you can't pay bank fees from somebody else's money. So you can put in your own money as a cushion, basically to avoid bank fees. And you obviously keep record of that when you have your trust account. Only checks payable to the broker may be used to withdraw money designated as the broker's funds. What does that mean? Basically, no cash withdrawals. There has to be a paper trail. So nowadays, there are things like ACH and wires and so forth and so on. But again, there are no cash withdrawals. There has to be a paper trail that can be followed of money coming in and out of that account. You have to have some accounting system. GREC doesn't require anything specific. They don't require QuickBooks or anything like that. It can be anything as long as it is readily accessible, GREC can understand it, and is reasonably available to GREC. It can be on paper and pen, a software program, even if you use an accountant or a CPA, their accounting or reconciliation of your trust account. A broker who disburses funds from their trust account contrary to the terms of a contract will be considered by GREC to have demonstrated incompetence to act as a real estate broker in such manner, again, as regarding safeguarding the interest of the public. You guys all got that one correct on the quiz. A broker who disburses money from the trust account. You guys, basically what all these license laws are saying, it's really easy to make a deposit into a trust account. It's a little more tricky to take money out of a trust account. Again, why? Because it's not your money. It's not the broker's money. It's not the holder's money. It is money that belongs to someone else. Generally speaking, a buyer or a tenant. However, if there's ever an issue with a termination of a contract or a default, that money could belong to a seller or a landlord. So it's somebody else's money. So in order to take money out of that account, there are very specific laws regarding that. A broker can take money out of the account upon the rejection of an offer, withdraw of an offer not yet accepted, at the closing of a contract, if you receive a written agreement signed by all parties having an interest of the funds, separate from the contract that directed the broker to hold those funds. Okay, what does that mean? We deal with this all the time. That is the termination and release. So a lot of times the contract, the initial purchase and sale agreement that goes binding between a buyer and a seller, who are the parties those are the parties that have an interest in the funds. That contract is the one that directs the holder, the broker, to hold the money. If a contract terminates, we can't, even if there's a due diligence period, so forth and so on, you can just give the money back to the buyer, even if they terminate before the end of due diligence, if you do not have a written agreement signed by the buyer and the seller. This written agreement is separate from the contract that directed us to hold the money. So the purchase and sale agreement gives us the information that we need to figure out whom to disperse the money to, but you can't just disperse earnest money on a termination without a signed release agreement signed by both the buyer and the seller. Well, what happens if the buyer and the seller don't agree on who gets the earnest money on a termination? Well, then you can send it to court and let a judge decide, and that's called an interpleader action. You can be under court order for a variety of reasons, or a broker can do what license law says is a reasonable interpretation of the contract. We call that a 10-day letter. It says I'll show you in the GAR contract why we call that a 10-day letter a little bit later. A broker, still in with license law, a broker shall not disperse trust money until they have reasonable assurance that the bank has credited those funds to the broker's account. So there are some bad guys out there that try to swindle brokers out of money. It would be a buyer that would write a personal check for a business check for, let's say, $5,000, and then they'll immediately terminate. And some brokers would just immediately give them their money back. And then lo and behold, that check is no good. So license law says a broker does not have to disperse those funds until, even if there's a termination, even if it's fully executed, until you are assured that that money is in your account. So here's a broker point of practice. Have a policy. Broker may also have a policy about releasing funds from their trust account. And your agents, you should direct your agents to check with whomever the holder is what their policies are regarding that. And I'll cover that a little bit later in the class. For example, a 10 banking day hold on personal checks, a 1 day or 2 business day hold on certified funds, something like that. But you need to have a policy to make sure that you don't get swindled out of money. When a broker makes a dispersal to which all parties do not agree, the broker must immediately notify the parties of the written dispersal. Again, that's the notification. We call that the 10-day letter based on the GAR contract, and we'll get to that a little bit later. A broker who claims any part of the trust funds paid to the broker in connection with the sale as part or all of their commission shall be deemed by GREC to have complied with the law. So money's in the trust account, and now it's like, okay, part of that is going to come to the broker to pay as commission. So you can do that if the transaction is closed, if possession's been delivered on a lease, if the transaction is closed or date of closing extensions have passed, upon receiving a written agreement, again, separate from the contract or lease, signed by all parties having an interest in the transaction who have agreed that the broker is entitled to any commission. All refunds of trust funds must be paid by check or credited at the closing. Again, you need a paper trail. The total of all checks written against each deposit should reflect the zero balance relating to the closing of each transaction, again, or termination. Zero balance should also occur when brokers transfer funds out as their commissions. If a license, hang in there, you guys, we're almost done with the license laws, and then we'll get to some more of the actual nitty-gritty. If a licensee who owns a trust account files a bankruptcy petition, such licensee shall immediately notify GREC in writing of the filing of that petition. If a qualifying broker or the real estate firm itself that a licensee serves as qualifying broker files a bankruptcy petition, the qualifying broker must immediately notify GREC in writing of that filing. Now, here's what I mentioned at the top of the class. A licensee who manages rental property, which the licensee owns 100%, must maintain any security deposits in a designated trust account and may not post a bond in lieu of maintaining such deposits. Again, if the broker allows an agent to have a trust account for security deposits, typically, license law says that is only the case if the licensee owns that property 100%. If that property is owned by an LLC, the licensee must be the sole member of that LLC. If you guys have agents that have investment properties held with a spouse, a child, a business partner in an LLC where there are members other than your licensee, even if your firm allows agents to hold trust money, license law says they cannot do it. Why? Well, because GREC these license laws only apply to someone that holds a real estate license. So if there is an investment property, a rental property, and the title is held by a licensee and by somebody who doesn't hold a real estate license, GREC has no jurisdiction over that person. That's why, and again, it's not protective of the public. That's why, again, for any of you brokers, or if you are an agent, obviously you're an agent, but if you hold investment, if you have a rental property and your broker does allow you to hold security deposits, if you are not the sole person on title, you still can't do it by license law. You have to keep records for 3 years. 3 years, a true and correct copy of all sales contracts, closing statements, any offer or other document that resulted in the depositing of trust funds, accounting records related to the maintenance of trust funds required by this chapter. Broker appointed practice. I suggest you have a policy about offers turned into the broker if you already have the earnest money on deposit. So, what does this mean? Based on this license law, some brokers don't require their agents to turn in every single offer. However, if there is an offer that never turns into a contract, but you already have earnest money on deposit, you do need a copy of that offer per this license law. So again, think about it. We have a lot of buyers nowadays that will write an offer on a property. They'll go under contract. They send the earnest money, you deposit the earnest money. You have that earnest money on deposit. The buyer then terminates the contract before the end of due diligence, but they're going to continue to work with that agent and go find another property. They direct you, I'll cover this a little bit later in the class, to hold that earnest money on deposit until they find another house. They then write an offer on house number 2. You already, as a broker, have on deposit their earnest money. That offer on house number 2 never goes binding. They then write an offer on house number 3. You're already holding earnest money because of the first contract that terminated. House number 3 goes binding. Obviously, you're going to have a copy of the contract on house number 1 because that was binding and terminated under due diligence. You're obviously going to have a copy of the contract for house number 3 because that's binding. This license law says because you had on deposit earnest money for the buyer's offer on house number 2, even though it never went under contract, you, by this license law, are required to have a copy of that offer because it resulted in the depositing of trust funds. It didn't result in that, but you already had trust funds on deposit. So that's what this point of policy is, a broker point of practice, is perhaps you want to consider having a policy in that situation. Now, let's talk about this a little further. This was a quiz question. You guys all got this correct, but I'm not sure if you're doing this or not. If you have earnest money on deposit from one contract and it terminates, may you transfer the earnest money to another contract? The answer is it depends. First of all, do you have a fully executed release agreement? If not, and you had to do a 10-day letter, have those 10 days passed and the buyer received the earnest money, or do you have a court order? So let's talk about this for a second. Again, buyer writes an offer on house number 1. They put in earnest money. You deposit the earnest money. Buyer terminates contract number 1, house number 1 on due diligence. You can, and the buyer says, your agent says, hey, I'm still working with that buyer. We're going to go find another house. Just hang on to the earnest money. You cannot do that. It is not your money. The agent cannot direct you as the broker just to keep that money on deposit. It is not the agent's money. Whose money is that? It is the buyer's money. So you can only keep on deposit earnest money from a terminated contract at the direction in writing with signature from that buyer. A lot of you guys are holding earnest money on terminated contracts till they find another house. You can't do that. So what do? Well, here we go. That's what I just said. No, it's not the broker's money. So what do? You need the buyer's written permission. If not, then you have to, on terminated contract number one, you have to terminate, you have to disperse the money. Well, that's so burferish. Why are you going to, that buyer's going to continue to work with your agent. Wrote a contract, you have the money on hold, they terminated under due diligence. Why are you going to send them their money back for them just to redeposit it with you? That's going to be so much time and so much paperwork, and it doesn't have to happen. But you need that buyer's written permission. So this is a sample of something you can do with your broker's permission. If you are a qualifying or managing broker, you are more than welcome to use this form. This is courtesy of Maximum One Companies. And what it says is it is transfer of earnest money between properties. Authorization to transfer earnest money held on a terminated contract or offer never accepted. So you have contract number one, it terminated, let's say under due diligence, no problems, buyer gets the earnest money back. Then your agent is going to have the buyer fill this out and sign it. It's from property address. This would be house number one that got terminated with disbursement of earnest money on a TNR to the buyer and the amount of the earnest money. Then you have where it's going to. If the buyer already has an offer on another house, you will have that property address. If not, you could put to be determined. Then here's the key thing. You have the buyer's written signature. So you have the buyer's written permission to keep their money on deposit until they find another property. Now, just a quick comment. Let's say buyer had a contract on house number one. It terminated under due diligence. They're going to get the earnest money back. However, the seller, for whatever reason, does not sign the release agreeing to release the earnest money back to the buyer. Either they're mad and they just won't sign it, or the listing agent can't get a hold of the seller for whatever reason. You then have to do a 10-day letter. And the 10-day letter, in my example, is the buyer will get their earnest money back because in my example, they sent notice of termination prior to the end of due diligence. However, you have to write that notice. You cannot disperse that earnest money to the party for at least 10 days from the date of the notice. Well, if you have to do a 10-day letter on terminated contract number one, buyer is still working with your agent. They go find a house number two. Seller number two is going to want what? Yep, they're going to want earnest money. You can't use the earnest money you have on hold because it is tied up in this 10-day letter. The buyer is going to have to put in additional earnest money. And then on day 11, from the date of your 10-day notice, you could disperse it back to the buyer. But that's really important for you brokers to understand. If you do not have a fully executed release agreement to disperse the money back to the buyer and you have to do a 10-day letter, you cannot use those funds you have on deposit for another contract. So I'm going to get into that a little bit later. But if that is the case, or whenever that is the case, you still need that buyer's signature directing you to hold the money for another contract. Woo, that was a lot. All right. we are going to switch gears a little bit and move into some of the verbiage in the GAR contract regarding earnest money and earnest money handling. A little bit with the purchase and sale agreement, closing attorney acting as holder exhibit, closing attorney agreeing to be the holder. And are there more chats? I'm missing some chats. Hang on. Why is my chat not working? Hang on one second. Main chat. Oh, there we go. All right. I am so sorry. I've missed some chats. So hang on. Yes, for those of you that have come in a little late, I understand the issues. There are no worries about that. You guys are all good. Okay, there we go. I'm back on the main chat again. Sorry. Okay, anyway, back to the slideshow. Acknowledgement of a person contributing earnest money on behalf of a buyer. That is a GAR form. Brokers, you guys are going to love, love, love this form. And it is a form that a lot of agents and brokers aren't familiar with. We're going to talk a little bit about a unilateral TNR, termination and release, and the mutual TNR. Okay. The purchase and sale agreement. You guys give me 1 second. Hang on 1 second. Thank you. All right, so we're going to start with the purchase and sale agreement. And again, this is not a contracts class. This is an earnest money handling class. So it does say in the Georgia Association of Realtors purchase and sale agreement, the holder of the earnest money. And that is designed to be one of the brokers, the buyer's broker or the seller's broker. If it is the closing attorney, GAR gives us a hint. If the holder is the closing attorney, F10 must be attached and F511 must be signed by the closing attorney. So I'm not sure what that gibberish is, but the closing attorney acting as the holder is the exhibit that must be attached to the contract. And on that form, let me see if I have, okay. Let me pull up that form just a little bit. There's a couple things I want to cover, but the buyer has 2 business days from the binding agreement to get the contract to the closing attorney who's the holder. After the contract is binding, that is when you as a broker need to be in possession of the GAR F511, the agreement of the closing attorney to act as the holder. It must be signed within 5 business days of receipt by the attorney. If not, then the alternate holder becomes primary holder. Let me go through my slides and then I'm going to point this out where it is in the form, because there are a lot of brokers that are potentially violating license law and going contrary to the terms of, where'd that come from? That's all right. I need it anyway. Let me pull up this and let me pull up. Pull up this one. All right. I'm going to come back to those in a second. So let me, from current slide. Let me finish going through the slides and then I'm going to show you guys just a little bit. But this is important because if the closing attorney doesn't agree to be the holder, you might be the holder of the earnest money. Broker point of practice. Check if your brokerage is the alternate holder and note the contract dates. If the closing attorney has not signed the agreement by the required date, you are now the holder. If it's blank, the buyer's broker is the holder. This is really important for notices of receipt and deposit. So now let me show you what I am talking about. So this form, and I'm going to make it bigger so you can see. And again, this is not a contracts class. I'm not going through everything. This is the exhibit. Your agents should be attaching this if the buyer and the seller negotiate for the closing attorney to be the holder of the earnest money. This paragraph number 7, so many agents leave that blank. It says the alternate holder. The buyer must well, first let me go back up here. The buyer has 2 business days to get the entire contract to the closing attorney. The closing attorney has to agree in writing to be the holder. If not, then the person here, the broker, it has to be one of the brokers, is the holder. If it's left blank, it is the buyer's broker. So what does that mean? That means if you or your compliance broker, if you get a contract and it has this exhibit and the buyer and the seller have agreed that the closing attorney shall be the holder of the earnest money, then you need to make a mark if you are especially if you're the buyer's broker or if you are named in there, you need to keep track of the dates because if not, you're the holder. One more thing while I'm here to make sure your agents are aware of. If it is an all cash transaction and the closing attorney is the holder of the earnest money, it doesn't close and you don't have both buyer and seller's signatures. Where'd it go? You don't have both buyers and sellers' signatures on the release. It has to go to court. The closing attorney basically cannot do a 10-day letter in an all-cash transaction. So just wanted to bring that to you. This is the document. This is the agreement. It's not part of the contract because it's not signed by the buyer or the seller. This is what you get after your binding with the closing attorney agreeing to be the holder, and it only requires the closing attorney's signature. But again, back to this, if you never get this or don't get it in time, you might be the holder of the earnest money and now responsible for all the responsibilities as holder of the earnest money as outlined in the contract and by license law. That includes what happens if you now are the holder. You never realized you were the holder and you never get the earnest money and you never send notice to the parties that you didn't get the earnest money. You are in a world of hurt. So back to the slideshow. Broker point of practice. Check if your brokerage is the alternate holder. Make note of the contract dates and the time frame that the closing attorney has to agree. If not, and you are now the broker, you now may need to send notice that you never received the earnest money. Also, again, I already talked about that. If it's a cash deal and it terminates and no agreement, the closing attorney may not do a 10-day letter. It has to go to court. All right. Woo. Moving on. The earnest money can be in any method of payment acceptable to the holder. So, brokers, you need to have a policy of what are acceptable payments and inform your agents. What type of do you have it by certain amounts? Like you'll only accept a personal or a business check up to a certain amount. Does it have to be certified funds over 5,000? Does it have to be a wire over 10,000? Do you accept ACH? Do you accept electronic payment like PayPal, Zelle, Cash App, so forth and so on? Brokers, you need to have a policy on this. Agents, you need to check with the holder of the earnest money what their policies are, if it's your broker or another broker. That should be time frame for holds on personal or bank checks and forms of payment. Another point of practice, based on a Homeland Security Act, if you are in possession on hold of over $10,000, if it is not a wire, you have to complete the IRS Form 8300, and that needs to be signed by the buyer. It has a ton of identification information on there, and a lot of buyers don't want to sign that. So, broker point of practice, if the earnest money is more than $10,000, it is best to receive a wire and make that as part of your policy. Now, this over $10,000, that's even in increments. If a buyer makes two deposits, one of 6,000 and another one of 6,000, that still falls under this Homeland Security Act. So a lot of agents and brokers are not aware of that. Now, you are the holder of the earnest money. What do you have to do? Woo, there is a lot that the contract puts on your shoulders regarding what you have to do with the earnest money. So that's in the GAR contract in the 2025 version, it's paragraph 6. And there is a contractual time frame to deposit, which is 5 banking days after the binding agreement date, or after the earnest money is out, the trust funds are actually received, if it's received after the binding agreement date. What does that mean? Well, a lot of buyers and sellers negotiate that buyer is to send the earnest money to the holder X number of days after binding agreement date. So if let's say it's 3 days after binding agreement date, then you have 3 calendar days after the binding agreement date for the buyer to even send it to you. And then you have 5 banking days after that to actually make the deposit. And then if you don't ever get the earnest money, or it bounces from the bank, you have to send notice to the buyer and the seller that you don't have it. Brokers, this is really, really important. Your purchase and sale agreement, in essence, is a receipt. This says when you are listed as the holder of the earnest money and it says $5,000, you don't get it. If you never put in writing that you don't get it, this is a receipt that you're in possession of that money. And if something happens, you could be held liable to have to pay out that money, even though you never got it. So brokers, this is really, really important, that if you don't get it, or it bounces from the bank, meaning it's still not on deposit with you, you need to send a notice saying, whoa, this receipt is not valid. I am not in possession of these funds. And that is a buyer default. The buyer has 3 banking days to cure that default. If not, the seller has 7 days after that to terminate. Also, brokers, if your bank charges any fees, like a bounce check fee, NSF fee, something like that, stop payment, if the buyer stops payment, you are allowed to charge that buyer with those bank fees. So again, these notices are really important, because a seller would want to know if there's no earnest money in there and have termination rights, rather than waiting 30, 45 days to find out. And again, this is a receipt for the money. So further on in the GAR contract, it does say that when the affiliated licensee, when your agent signs a purchase and sale agreement and your brokerage is the holder of the earnest money, when you sign an independent contractor agreement with them, you are giving them you are giving them permission to engage you with all the responsibilities as holder of the earnest money. So I made a big deal about the closing attorney's signature not being on there. Your signature isn't on there either, but your agent acts as your accepting responsibility per the contract to fulfill all these obligations with respect to earnest money. Now, again, just a couple of notes about the earnest money not being sent or not honored by the bank. The broker must track the timeframes as part of compliance when the earnest money should be deposited. They must send notice to the parties. This is sort of what I just said. Broker must send notice of default and if it's cured or not. This issue does have seller termination rights, so the broker must track this. If the closing attorney is the holder, the broker needs to remind the agent to remind the attorney of their contractual obligations of holder. So in other words, if the buyer and seller decided that the closing attorney should be the holder of the earnest money, your agents need to stay up with the holder, both on the buyer's side and the seller side. Okay, closing attorney, did you get the money? Did you deposit the money? Did you get the money? Did you deposit the money? If not, okay, closing attorney, you need to send notice of default to the buyer, and because that's what the contract says you are supposed to do. Now, moving along, more about the disbursement of the earnest money. And again, we know this, and this is a lot of this is to keep us in compliance with license law, but it is in the GAR contract where it states that if it closes, it gets credited to the buyer at the closing, so forth and so on. Or if you get a court order, what I said at the beginning, per license law. But here's where we get the 10-day notice. Remember, license law says that you can only disperse money out of the trust account if it hasn't closed upon termination. If you have written agreement signed by the parties that have an interest in the funds separate than the document that directed you to hold it. Well, we call this the 10-day letter. If you go, one of the options, if you don't get that agreement, is to interpret the contract. Why do we call it the 10-day letter? Because the holder can do a reasonable interpretation of the agreement, but you have to give all parties at least 10 days. You give them a notice of whom you're going to disperse the earnest money to and why. You have to give them 10 days, the person not getting the earnest money, to make an objection. That's why we call it the 10-day letter. As much as you would like to, sometimes it would be nice to say, hey, I want to divide up the earnest money. The seller did a little wrong. The buyer did a little wrong. I'm going to split it. You cannot do that. A judge can do that, but you cannot do that. As the holder of the earnest money, you have to treat that as one big pile of money and can't divide it up. Now, a buyer and a seller can put in writing, hey, we want to split it 50-50, 70-30, 60-40. And if they agree to split it and sign it, you can do that, but you cannot split it yourself. After you write the 10-day letter, if you get an objection, if it's based on the contract, something you didn't see. Let's say there was an amendment that ended due diligence period early or something like that. If you never got a copy of that amendment and you change your mind, you have to do a new 10-day letter. If you get an objection, but it still does not change your mind, then the original 10-day time frame is still in place. Now, here's another thing. The GAR contract, this is not law, this is not Georgia law, this is a contract provision by the Georgia Association of Realtors. If you are holding earnest money and you end up dispersing it to the seller, the holder may require the seller to sign a W-9 before they issue the check to the seller if that amount is $600 or more. Guess what else that means? At the end of the year, you're going to send that seller a 1099 and they're going to pay taxes on that money. Now, another way earnest money comes out is an interpleader action. Sometimes it is too complicated a contractual or legal issue. Sometimes it's too much money and you have a broker's license. You are not an attorney. So sometimes you're like, you know what? I am going to let a judge make this decision. If you do that, you have to hire an attorney to file an interpleader action with the court. There are court costs and legal fees. You get to get reimbursed by the party that loses your costs, and those come out of the earnest money. This paragraph here where it says the prevailing defendant is entitled to collect its attorney's fees, court costs, and amounts from the non-prevailing. That means the judge can say, okay, loser, you have to pay not only back the holder for their fees and costs, you also have to pay the winner their legal fees and costs. And then we love this. Thank you, GAR. There is an indemnification and hold harmless statement that the parties agree to not sue you regarding your disbursement of the earnest money. Obviously, you can't commit fraud, but if you do go by the contract, they agree to not sue you. Now, all that being said, anybody can sue anybody for anything. So buyers and sellers can still sue you. But if they do, you're going to hire an attorney that's going to argue to the judge, hey, buyer and seller signed this agreement. They agreed to not sue me. So they can still sue you. But if you have a savvy attorney, they're going to defend you based on this paragraph. So all of that I just said is spelled out in these slides, that the holder the 10-day letter, the holder may interpret the contract and send notice to the buyers and sellers of their intent. You have to send it per the notices section of the contract. I suggest you send it not only to the buyers and the sellers, but to the brokers and agents as well. You have to wait that full 10 days before you disperse the money. So the earliest would be 11 days from the date of the notice. And again, if there is a valid contractual objection, you could change your mind and do a new 10-day letter. You need to get the address of the actual buyers and sellers. And again, you may require a W-9. That's only a GAR contract provision. And again, as I mentioned earlier, this earnest money is tied up until released. So in my earlier example, where your buyer is still working with your agent, they're going to go write an offer on house number 2 or number 3. If it's within this 11 days, they're going to have to put in additional earnest money. You cannot use earnest money tied up in a 10-day letter for another property. Couple notes on an interpleader action. Always give the parties notice of your intent to interplead and give them the opportunity to come to an agreement to divide up the money between themselves. There are lots and lots and lots of fees associated with an interpleader action, legal fees, court costs, and it gets deducted from the earnest money. And as I mentioned earlier, there are other fees that one party may have to pay the other party. So it is a lawsuit that will cost time and money, and someone's going to have a civil judgment against them. And I don't know of any buyers and sellers or anybody that wants a civil judgment against them. So we have some examples at the end of class of some 10-day letters and some notices of interplead. You should give them a time frame to actually negotiate this between themselves before actually sending it to court. Moving on a little bit. If the source of the earnest money is not from the buyer directly. So for example, let's say you have a parent that gives a gift to their child of the earnest money, that their adult child is going to write an offer on a house, and the parent is actually, the earnest money is coming from the parent's account. If the contract terminates and the earnest money gets dispersed to the buyer, it goes to the buyer on the contract, not the parent or whomever that puts up the actual money. Only the buyer is a party to the contract. So broker point of practice. This is a form, this is a GAR, Georgia Association of Realtors form, that you may not be aware of. And I highly suggest that you make your agents aware of this and have them use this if the buyer gets the earnest money from anyone else. And this is GAR form F525. And I've got a little bit bigger version of it so you can see it a little bit closer. This is a great form. This would be a great sales meeting, a great thing to discuss with your agents. Acknowledgement of person contributing earnest money on behalf of a buyer. You reference the offer date, the buyer, the seller, the property address, and the amount of the earnest money. It says the undersigned is paying earnest money to the holder on behalf of the buyer of X amount of dollars, blah, blah, blah. Holder, I just have the highlighted points underlined. Holder shall hold, handle, and disperse the funds as if the earnest money was paid solely by the buyer, and shall only deal with the buyer regarding the same. And then it gives examples what I just said. If the buyer, if there's a default, the earnest money might go to the seller, or if the earnest money goes back to the buyer. If the earnest money is to be returned, it will be returned to the buyer and not the party who paid the earnest money. It also goes on to say that as broker, you do not have to have any conversations with the party that put up the money regarding the contract. And it is signed by the person contributing the earnest money on behalf of the buyer. Again, I highly suggest you get your agents to use this form. If earnest money, the source of the funds is anyone other than the buyer. They also need to check with the lender, but this will save you a lot of phone calls and headache and a lot of disgruntled parents, significant others that actually put up the money and don't get it back. Hang with me. We're gonna finish a little bit of the purchase and sale agreement, and then we'll take a break and continue on. So under the default section, basically, if the buyer defaults, this is all spelled out here, and this is the newest version of the GAR purchase and sale agreement that includes the revision that came out in June of this year, 2025. If the buyer defaults, the seller gets the earnest money. The seller may sue the buyer if the buyer never remitted and defaults. I'll come to that in a second. That's a provision, a contract provision that came out mid-year. If the seller defaults, the buyer can either terminate the contract and get the earnest money back, or if the buyer can sue the seller for specific performance. What does that mean? That means they go to court and a judge, it's not a money lawsuit, it's a contract lawsuit. The judge says, okay, seller, you have to go through with the contract with this buyer and fulfill the contract. If your buyer does initiate a specific performance lawsuit with a seller, the earnest money stays on deposit. Now, in January of 2025, GAR added that if a seller defaults, because we had a lot of issues where we had a seller, they were under contract with a buyer, they got an offer, another offer from buyer number 2 that was for more money. We had sellers terminating contracts by default right and left and said, I'll default. I don't care. Okay, buyer number 1, you get your earnest money back. Go find another house. It's worth it to me because I'm going to accept this contract from buyer number 2 for more money. GAR added that if a seller defaults, not only termination and earnest money back or specific performance, but it says right here, buyer may pursue any other remedy available at law. So buyers can sue sellers if a seller defaults, throws their contract away just for a higher contract. So sellers and listing agents, your seller cannot just think it's not just, oh, no big deal, I'll just give the buyer back their earnest money. They can be sued. So I want to let you know that. That's this new, what I have underlined here under remedies of buyer. Under remedies of seller, this part was added in the June revision. This means we had a lot of buyers that were writing offers on or going binding with a seller. They would do a short due diligence period. Let's say they did a 3-day due diligence period. Let's say they never sent in the earnest money and they terminated on day 5. Well, we had buyers that were absolutely defaulting on the contract, but they thought, oh, well, no big deal. I never put in the earnest money anyway. I'm just free, scot-free, and going on my merry way. Well, now sellers may sue the buyers for earnest money that was either not paid or turned in, or if they stop payment. So, okay, you buyers agents now, just because a buyer doesn't send earnest money, they don't get off scot free clear. They are still liable for that money, and the sellers can sue them for that. Here's something to remember. If earnest money is part of the creation of a contract, it is also must be addressed in the termination of a contract. Just because it's physically not on deposit with the holder, it is still part of the contract. And think about it, that makes sense. A loan is a huge part of the contract. But when a buyer and seller go under contract, the loan's not there. That's why we have 30, 45 or more day closings. But the loan is still a huge part of the contract. So the seller can sue even though they terminate during due diligence. No, there's this is just if a buyer defaults. If a buyer defaults, terminates by default, but they never put in earnest money, that's when the seller can sue. If a buyer terminates within an agreed upon contingency, whether it be due diligence or a finance contingency, appraisal, whatever, the seller can't sue them for that. They agreed to the contingency. This is just, remember, we're in the default section. This is just if a buyer defaults and have never put in earnest money. All right. Okay, that's what I just said. Oh, no, this is a little bit different. The termination of a contract is a separate issue from the disbursement of the earnest money. GAR addresses these two issues on one form. We've got the top part that says one of the parties is terminating with only one signature, because you only need one signature to terminate. And then the bottom half is the proposed disbursement of the earnest money. These are two completely separate issues, even though they're on one form. Once a contract is terminated, the seller may put the property back on the market as active and accept another contract, even if the termination is by default, and even if there is a dispute over the earnest money. Again, notice means you only need one signature. Unilateral means one. It's either party may terminate, buyer or seller, and these are the reasons, and it's only signed by the party giving the notice. Both parties, however, their signatures are required to disburse the earnest money based on this form. And again, this is in keeping with license law that we covered at the beginning of class. Now, the parties may choose to have you, the holder, divide that money, but again, you as the holder may not make that decision. So this is the proposed earnest money be dispersed as follow. To whom the earnest money that's spelled wrong is to be dispersed and how it's to be divided. This disbursement is only effective upon this form being signed by and delivered to buyer and seller with a fully executed copy of the same, and then being delivered to the buyer, seller, and holder. So this says and. You need buyer and seller signature to disperse it based on here. The majority of terminations we see are by unilateral termination and release. Typically, that is a buyer terminating based on a contractual contingency, due diligence, financing contingency, appraisal contingency, sale or lease contingency, so forth and so on. This is the majority of the terminations we see. However, there is a mutual termination and release agreement in the GAR contract package. This is typically used as a settlement agreement if a party defaults or if a party is not going to close, but it is still weeks from closing. I'll elaborate on that example in just a second. It is also the form used to negotiate compensation to the brokers. The contract is not terminated until all four parties sign. So this mutual termination and release, this is typically, let's say, let me use this example of a sale or release contingency. So buyer and seller, here's an example. Buyer and seller are under contract. The buyer, part of this contract is a sale contingency, meaning the buyer has to sell their current home first before they can buy this new property that we have under contract with the seller. And it says on that form that the buyer has to close on their current home by, let's just say, September 30th. Well, we know for whatever reason, let's say it's September 1st, September 2nd, September 3rd. Buyer still doesn't even have a contract on their house. We know that buyer is not going to meet this contingency and close on the house with the seller. The seller is still tied up for 30 days. The buyer doesn't want to terminate because they don't want to terminate by default and lose the earnest money. The sale or lease contingency exhibit, which is not a contracts class, it has verbiage in there that if the buyer doesn't do that, the contract automatically terminates. Buyer will get their earnest money back. So the buyer can just say, you know what, let's go ahead and terminate now, so the seller can go back on the market as a true active listing without having to stay off the market for another, for example, 30 days. So if that's the case, you would probably want to use this mutual termination release. You don't want to use the unilateral, because the buyer would default. They don't have termination rights yet. And as soon as they sign this, they've terminated and they're in default. With the mutual, the buyer can initiate this or the seller can initiate this, and it is not fully terminated. No one defaults until you get buyer and seller and broker signatures. So this would be the amount if either of the brokers wants commission. This is where you spell out commission. And this is what happens to the earnest money. And it is signed by buyer and seller. And buyer's broker and seller's broker. So again, this is a good form if there is going to be a default or something, because again, nobody defaults by initiating this because it's not actually terminated until all four parties have signed. All right. Summary of holder of earnest money. Accept earnest money in a form acceptable to the holder. Again, you as a holder need to have policies on this and convey this not only to your own agents, but if you are holding earnest money and the buyer is represented by an agent that's not yours, you need to make sure that that buyer and their agent know what your holder policies are. Agents, you need to, and brokers, teach your agents to check with the holder on their policies regarding earnest money, forms of payment, dollar amounts for certified funds or wires, so forth and so on. Deposit within 5 banking days of the binding agreement or receipt of the earnest money. And again, I gave that example if the buyer doesn't have to send the earnest money until X number of days after binding agreement. So the holder obviously doesn't make that deposit until after it has been received, but they've got 5 banking days. Does not have to return or credit money on a closing until it's assured it has cleared the account. Keep this in mind for quick closings. So brokers, you may want to have a policy. You may want to have a policy of just certified funds only. It's much easier and faster to act on certified funds and wires rather than a personal check or a banking check. Also, be careful for an ACH. It is quicker, but a buyer can stop payment and reverse an ACH. If earnest money is not honored by the bank or not received, the holder must send notice to the parties of the buyer's default. Buyer has 3 banking days to cure. Seller has 7 calendar days thereafter to terminate or stay in the deal and go to closing with no earnest money involved. You guys got all that correct on the quiz. Earnest money is not required for a binding or enforceable contract. So you can go to closing without any earnest money. And holder may charge the buyer with any bank fees on top of the earnest money. As an agent, do not hold earnest money. You must get to the broker as soon as practically possible per license law. As a broker, you may want to have a policy on a certain number of days when your agent is to turn in that earnest money. Agents, and also back with you guys as brokers on deposit. Again, license law says you have to deposit that promptly. That means you cannot hold earnest money. There are some brokers that have or used to have a red envelope system and a white envelope system. You as a broker, if your agent gives you earnest money and puts it in a red envelope and says, okay, broker, you need to hold this earnest money until I tell you to deposit it. You cannot do that. That is a violation of license law. You have to adhere to license laws and the contracts regarding the handling of earnest money, regardless of the direction of your agent or the buyer. Agents on both sides should follow up on the earnest money deposit and request proof of deposit, regardless of who is named holder in the contract and which side you represent. I don't care if it's your broker, the other broker, or a closing attorney. You need to direct agents, both on the buyer side and the seller side, to follow up with the holder. Did you receive the money? Did you deposit the money? Did you receive the money? Did you deposit the money? The proof of deposit is what is most important. Again, both buyer and seller, and frankly, the agents and brokers too, but buyers and seller, it's important to know the buyer is in earnest and acting in good faith with respect to this contract. And if there's an issue, nothing's an issue till it's an issue. But if there is an issue, potentially a seller has claims to that money. You want to make sure the holder has that money on deposit. Another point of practice, if the earnest money is to be a wire, we know there is a ton of wire fraud, and it is emails that are getting hacked. So never have your agents email or wire instructions to buyers, sellers. Never have your agents email wire instructions from a closing attorney to either party too. And I highly suggest you have a policy on that, because it is the emails that are getting hacked and so much wire fraud. So highly suggest that if your agent's buyer is going to wire earnest money, that the wire instructions be handed to them physically or sent via US mail. It's going to take a little bit of a longer time frame to get those wire instructions to the buyer. So direct your agents, if that is going to be the case, in the contract where it says buyer to remit earnest money to holder within, instead of it being 3 days, make it a little longer if it's going to be a wire, and explain to the other party why that is the case. And again, check on the policy of the holder in terms of the form. Never, never, never accept cash. This is just a reiteration of what I said. Do not commingle funds. We have a lot of agents that try to be nice and they think they're doing the right thing, but they're violating license law. If they're in a quick contract or a competitive situation, or the buyer is out of town or out of the country, and the buyer goes under contract and they have to send in earnest money, it is a license law violation for your agent to say, well, the holder doesn't accept Zelle, Cash App, PayPal, but I do. So just electronically send me the money and I'll write a check for earnest money. Nah, total license law violation. Cannot do that. Earnest money in certified funds or wire or money order may be released much faster than a personal check or a business check. Again, buyers can always stop payment on a personal check. Buyers may rescind an ACH payment. If the buyer remits funds to the holder directly, brokers, you need to direct your agents what they need to tell those buyers to include a note of the property address and the agent's name. I'm going to cover that in a little bit more depth in a minute. If the earnest money is over $10,000, then again, I've already addressed this. I highly suggest you have a policy that it must be a wire to avoid having to have the buyer fill out this IRS form. Earnest money is liquidated damages and is the only remedy for the seller if the buyer defaults. Earnest money is not required for a binding contract. Agents are responsibility to follow up with the holder. I've already said that. Okay. There are, let me see what else I have. Okay, before I get to the intent, well, you know what? I'm going to come back to this. Let's do this. I'm going to talk about this. Let's take a break because this is a really important point and it's going to impact your agent's relationship with the buyer and your practices as a broker. So we're going to cover that a little bit more in depth when we come back. So let's take a break. It is 11:15. Let's come back at 11:30 and we will finish the rest. When you come back, please again type in your name, email address, license number, and we will knock out the rest. We finish at 12:30. We'll knock out the rest when we come back. So let's take a 15-minute break. Zoom recording. All right, welcome back from break, everybody. We are continuing on with some earnest money points of practice. When we last left our heroes, here's where we were, like the cliffhanger from the Saturday morning cartoons. Anyway, I'm going to talk a little bit about this because your agents, you as an agent, when you are working with a buyer, you tell your buyer, okay, I want you to write a check for thousands and thousands and thousands of dollars. Let me stop share for a minute. Your agents work with buyers. They tell your buyers, I want you to write a check to my brokerage for thousands and thousands and thousands of dollars, but don't worry, it's safe. You're completely protected in a contract. We're going to write in a due diligence period. And if the seller doesn't accept it, we won't go binding. So we'll make sure your earnest money is safe with some contingencies, a finance contingency, appraisal, blah, blah, blah. But the due diligence period is the Mac Daddy protection for your earnest money because you can terminate for any or no reason. And what? Get your earnest money back. So that's what our agents are telling their buyers. Great trust, great rapport, great confidence, good, it's protected, good to go. Then what happens? So what does the buyer think? Well, let me give a couple of examples. So buyer goes under contract, they find a house they like, they have a due diligence period, and they terminate. And again, if we get the fully executed agreement to release, they do get their earnest money back right away. Go find another house, we're good to go. However, nothing is an issue until it's an issue. Here's the deal. The deal is your agent's buyer writes a check for earnest money. They have a 5-day due diligence period. It's on deposit, thousands and thousands of dollars. It's on deposit. They terminate under due diligence. The seller does not sign the agreement to release the earnest money back to the buyer. I've already mentioned this a little bit within a different context. So what happens? Well, your buyer's like, okay, great, let's go find another house. They find another great house. And because seller on house number one didn't sign the release agreement, the broker has to do a 10-day letter. That earnest money, as I've already mentioned, is tied up until it's released. You cannot use brokers. We cannot use that earnest money for a second contract. It is tied up in this interpretation. Objections, or could be an amendment we didn't see, so forth and so on. So buyer finds house number two, and seller number two is going to want what? Earnest money. So your agent has to go to that buyer and say, okay, I need you to write another check for thousands and thousands of dollars. And the buyer's like, whoa, wait a minute. You told me my earnest money was protected and safe with your broker. What on earth has your broker done with my money? What did they spend it on? Why don't they have it? Why are you asking me for more money? What's the deal? What's going on? And your agent has to explain to them that it's tied up, you'll get it back, blah, blah, blah. What if the agent's wrong? What if the agent, there was a mistake? What if there was an amendment to address concerns that terminated the due diligence period early and your agent forgot about it? Or what if your agent messed up the time frames and they terminated under due diligence a day late, or they got the buyer's signature before the end of due diligence, but they didn't send notice to the seller till the day after? There's all kinds of things. But a lot of times, if the buyer is getting their earnest money back, but you just have to go through this process, you have weakened that relationship and that confidence and that trust between that public buyer and your agent. And that is something that you as a broker can potentially prevent by having these earnest money handling discussions with your agents at sales meetings, through whatever means you communicate with your agents. You need to have your agents have these discussions with these buyers up front before it's an issue. So they can say, remember when we talked about that? It is safe. You will get it back. It's just a little delayed. Or teach them to negotiate in a contract earnest money to be remitted within 14 days or something like that. Now, here's another thing. Your buyer, so we've already sort of addressed that many times. Here's another thing. Your buyer goes under contract and there's thousands of dollars of earnest money. And again, we know that means it's in good faith and so forth and so on. And the buyer doesn't physically hand the earnest money to the agent, but the agent says, look, just drop it off at my office or send it in the mail to my office. And that's what happens. Your buyer writes let's just say it's a personal check for $4,000. They write a personal check to your brokerage, they mail it into your office, and the staff gets it. One of two things happens. Here's an envelope, and it has the agent's name on it. So the staff member goes, do, 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 do. Look, Dana Sparks got some mail. Yay, Dana. Let me go put this envelope in Dana's agent mailbox at the office. Do, 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 do. Never opens it. There's earnest money in there. It never gets deposited because it's sitting in the agent's mailbox. Agent never comes in to look at their mail. Or staff gets an envelope payable to the brokerage. They open up the envelope. Here's a check, personal check, bank check, whatever, payable to the brokerage for thousands and thousands and thousands of dollars. And in the memo section, guess what it says? Earnest money. That's it. No property address, no agent name. And a lot of brokers keep track of their contracts by property address or at least agent name. We don't always have the buyer's name, especially if it's like an LLC or an estate or whatever. Or we get a personal check, and in the upper corner, it has that buyer's current address. Well, that does us no good either. So what do we do? Well, brokers, you guys need to still deposit that check. I highly suggest you have like an orphan deposit, an orphan account where you deposit these orphan checks until you have a home to put them in, a foster account, I guess. But we don't know. Staff doesn't know where to attribute that earnest money to, what transaction. So then guess what happens? The time frame passes and the broker sends notice to the buyer and the seller saying, hey, buyer, you're in default. Shame on you. You're in default. You never sent that earnest money. And the buyer's like, whoa, what is going on? I sent that earnest money. I mailed it where you told me to mail it to. Blah, 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 blah. What did your broker do with my money? Why didn't they get it? Why are they saying they didn't have it? What have they done with my money? I'm not default. And they get embarrassed in front of you, in front of your agent, embarrassed in front of the seller. It can potentially make the rest of the negotiations go south. It's like, what on earth is going on? Well, that's because your agents, you as a broker, may not have instructed your agents to instruct them what type of information the buyer needs to include when they're sending earnest money, whether it be a personal check, a bank check, even a wire. So these are some of the discussions that as a training, as a broker, you guys need to really educate your agents with these discussions regarding earnest money handling. So I just wanted to give you a couple of examples, and let me go back, and that is why on the slideshow I have, again, to follow up with not only with whomever the holder is, if you're representing the buyer or the seller, and did you deposit it? Now, did the agent deliver it to the holder, or did the buyer mail it in, deliver it in, wire it? What address did the buyer use? Some brokerages and some closing attorneys have multiple offices throughout Metro Atlanta. Where did they actually sell it? What was the name on the envelope? Was it the agent's name and sitting in a mailbox somewhere? What memo was written on the check? Was there a note in the envelope? Again, how will the staff at the brokerage know what transaction to attribute it to? Here are some broker policies on earnest money to consider. When is it agent to turn in the earnest money after possession? What policies do you have for physically turning it in, remotely, electronically, remote deposits, third-party deposits, so forth and so on? Software to do that. Notification to the broker when it's turned in. Must agent handle the earnest money, or may the buyer be permitted to remit it themselves? What contract and agent information as a note accompanying the earnest money? Those are, again, some examples like I just gave. What forms, here again, some suggested policies for you brokers. What forms are acceptable funds? Certain amount, like a certain amount in certified funds, more on a wire. What policies do you have regarding when the funds are available? A certain banking day hold on personal or business checks, on certified funds. Do you accept ACH or electronic funds? Written confirmation of deposit by the holder if the broker is not the holder. In other words, have your agent, if you're not holding that earnest money, have your agent get some sort of written confirmation of the deposit. Again, if earnest money is addressed in the creation of a contract, it must also be addressed in the termination of a contract. Oops. Required language on a termination release if the earnest money has not yet been remitted. A lot of agents miss this. So let's say that the contract says buyer to remit earnest money to holder within 5 days of binding agreement date. Let's say for whatever reason, and let's say there's a 7-day due diligence period, the buyer terminates the contract on day 2. So a buyer terminates the contract prior to the end of due diligence, but they haven't even been required to send it in. So on the TNR, your agents need to write, you still have to address the earnest money, even if it has not been sent in. So that's why I have this language here. Buyer to retain earnest money not yet remitted per paragraph A7B of purchase and sale agreement. Again, brokers, you need to instruct your agents. If Earnest money is addressed in the creation of a contract. It must also be addressed in the termination of a contract, regardless of where it is physically. All right. Moving along, we're going to finish up with 10-day letters. I'm going to give you guys some notes and then some samples. So, notice of intent to disperse earnest money, or the 10-day letter. Sometimes these are extremely easy. Sometimes these are very difficult. Sometimes the issues are very, very clear, and sometimes there is a lot of gray area. Did the termination occur by an agreed upon unexpired contingency? Did the termination occur by default? Do parties not agree to the proposed disbursement because they're being difficult? The agent can't find the party. The issue of the termination is a little bit uncertain. Is there confusion on contingency deadlines? There is a whole lot that the holder, your brokers, have to research and consider when writing a 10-day letter. Brokers, we have to do a lot of research. You need to look at the contract, all exhibits, all amendments. Sometimes your agents forget to turn in some amendments. So ask your agent if all the amendments have been turned into the broker. Make sure that what has been turned into the broker is actually a fully executed amendment. Does it have signatures from buyer and seller? Ask the agent who sent the termination for a copy of the email when the notice of termination was sent. I used it as an example a minute ago. There's a lot of times where, let's say the due diligence period ends tonight. Well, it would end tonight, August 21st at 11:59 p.m. So again, it could be that the buyer signs the termination before 11:59 p.m. tonight, but the buyer's agent does not send it to the seller's agent until tomorrow, which would be, even though the buyer has signed it before the end of due diligence, it has to be signed and notice of termination sent to the other party before the expiration of the time frame contingency. So just because the buyer signs it tonight before 11:59 p.m., if the buyer's agent doesn't send it till tomorrow, guess what? The buyer has just defaulted on the contract and terminated outside of the due diligence period. So you need to ask the email for a copy of the actual email when the notice of termination was sent. Ask the agent about the decision. Why did the buyer terminate? Why did the seller terminate? What happened? Give me a little bit of background. What's going on? Check all the dates on your contract and your amendments. Binding agreement date, contingency dates, date and time of termination notice sent. Also, human nature is to side with the person who gets to you first. Do not always side with your client or your agent or whichever party got to you first. When we have to do a 10-day letter, obviously it's one of your clients that's involved and has a stake in the money. But you really have to take off your client broker hat and put on your neutral third-party judge hat. You are entrusted, when you are the qualifying, managing, or compliance broker of a firm, you are charged with basically being a judge if it comes to this, and you have to do the right thing. Doing the right thing is always the right thing to do, regardless of the parties and which side you represent. You have to do the right thing with respect to the contract and what the buyer and seller agreed to in the contract. You truly have to be neutral, but you also need to do your own due diligence and do your own research. You need to get the mailing and email addresses of the co-op agent and broker and the email address of your client. Notice to a broker is acceptable if the broker is representing the party as a client. However, if the broker is accepting either the buyer or the seller in a customer relationship, you have to send notice to the public person that is the customer directly. But you always want to copy the broker. If you do a 10-day letter and thank you, and you disperse the earnest money, remember, the contract says you have to wait that full 10 days. In other words, if I write an earnest money letter today, August 21st, and I have to wait a full 10 days before I disperse it. So I can't disperse it on the 31st. That is still the 10th day that the other party has to object. I cannot disperse it until day 11 from the date of the notice. So a lot of brokers actually end up dispersing on that 10th day, but the day goes through 11:59 p.m. So don't disperse early. When you are writing a notice of your intent to disperse earnest money, we've received a lot of 10-day letters that are like form letters. They're fill in the blank, and it's not helpful at all. It just says, buyer terminated based on due diligence, seller didn't sign it, earnest money going back to the buyer. No, it's not. So a question is, isn't it the date the notice was received by mail? No, it is the date of the notice, the 10-day letter, the date of that notice of intent to disperse earnest money. It's 10 days from that date of that notice. Because we don't know when it was received by mail, especially here in Atlanta. We don't know when any mail's necessarily received. So I suggest, that brings up a good point though. I suggest you brokers, when you're sending 10-day notice, send it via US mail as directed in the contract and via email. So there's both. But anyway, I forgot what I was saying. Oh, so we get some 10-day letters and it just says, earnest money to go back to buyer because they terminated based on due diligence. You guys, you need to remember you're dealing with somebody's money and it's a lot of money. And when you are writing your 10-day letters, write them with the public in mind, with somebody that doesn't have a real estate license, doesn't deal with real estate contracts day in and day out. You need to fully explain why somebody is getting the money or somebody is not getting the money. Don't use jargon. Take some time and write it out. So here are some samples. We're going to finish up just with some samples. This is a sample, this is an easy peasy one. Notice of intent to disperse earnest money. And you would write out the agent's name, the broker's name, the address. You can do them anyway. GREC and GAR does not have any specific, I don't know why it keeps doing that. Does not have any specific formulas or formats or processes or procedures for 10-day letters. So your broker or you as a broker can write them out however you want. But for the purposes of this class, this is just a suggestion of how to do them. Full information for the agents and the brokers, the buyer's name, again, notice sent to buyer's broker because it was a client, and the property address. This is 123 Lucky Street. Based on my interpretation of the contract and the circumstances surrounding the termination of the purchase and sale agreement, we're notifying you that Maximum One Realty Greater Atlanta, or whatever the brokerage name is, will disperse the earnest money in the amount of X amount of dollars to buyer's name 10 days from the date of this notice. Please read for further explanation. We received some 10-day letters. That's all it is. And it's like, why? I want to know why, not what you're doing, but why. So again, I suggest you just explain it to keeping the public in mind as your audience of your 10-day letters. Determining factor. This contract had a binding agreement date of 2/16/25 and a closing date of blank. It was subject to 3 contingencies: a 21-day due diligence period ending at 11:59 p.m. on 3/9/25. A 15-day conventional financing contingency and appraisal contingency, both ending at 11:59 p.m. on 3/3/25. At 3:42 p.m. on 3/7/25, the buyers terminated this contract based on their right to terminate within the due diligence period and requested the earnest money be dispersed to them. The seller never signed the agreement. Then give them the proof. Based on paragraph B8E of purchase and sale agreement, buyer had the contract right to, quote, for any reason or for no reason to terminate this agreement upon notice to the seller given prior to the expiration date of the due diligence period, in which case buyer shall be entitled to return of the buyer's earnest money without penalty. The buyer complied with this contractual provision. Based on this reason, the holder will disperse the earnest money. Copies have been emailed and or mailed. Objections should be mailed, blah, blah, blah. So that's an easy one. Here's an easy one, but a little bit more explanation for the sake of a confused buyer. Again, you put all the contact information. This one, in my example, is 456 Fortune Fields. Based on the termination of the contract for the purchase and sale of property address, as holder of the earnest money of $6,000, maximum one greater whatever the brokerage the holder is will disperse these trust funds to the seller. As liquidated damages for the buyer's default 10 days from the date of this notice. Determining factor. This contract, I want to give the binding agreement date, the closing date, and all the contingency timeframes. You're like, why are you giving all the contingency? Well, let me go through it and then I'll tell you why I suggest you do this. This contract had a binding agreement date of 5/6/25 with an initial closing date of 6/5, later amended via the unilateral right to extend closing, and then amended again by amendment number 3 and 4 to a final contractual closing date of 6/27/25. It was subject to 3 buyer contingencies. A 7-day due diligence period amended via amendment number 1, thereby expiring 11/59/5/16. 15-day conventional amended to 20 days, therefore expiring, you give the date and the time. 15-day appraisal contingency amended via amendment, that should be number 2, not 32. Woo, 32 amendments. To a 25 days, thereby expiring 11/59 on 5/31. On 6/7/25, the buyer sent a notice to terminating because of other lawful reason. Buyer unable to obtain affordable homeowners insurance and requesting the earnest money released to the buyers. The sellers did not agree to release the earnest money to the buyers and failed to sign the proposed disbursement, thereby necessitating this notice with the holder's interpretation of the contract, which I'm allowed to do. Why? Because of paragraph B7B of the purchase and sale agreement. A buyer securing affordable homeowners insurance is not a lawful reason affording the buyers the right to terminate this contract and receive a refund of their earnest money. In order for a buyer to terminate a contract and receive the earnest money back, they must send the seller a notice of termination prior to the expiration of an agreed upon contractual contingency, due diligence, or financing or appraisal. That's why I always spell out all of the contingencies, because some of our buyers, they hear your agent saying their earnest money is protected based on contingencies, due diligence, appraisal, financing, whatever. So you want to spell out as the holder, yes, I have seen all of your contractual protections, all of your contingencies. So that's why you spell out, in my opinion, all of the contingencies and the timeframes, because your buyer doesn't understand. They're thinking, my agent said it's protected based on contingencies. So you want to acknowledge that, yes, you have looked at all of those. Anyway, continuing on with the letter. With a contractual reason supporting the termination based upon the terms of the contingency, a buyer is required to investigate and research this issue, the homeowner's insurance, during their due diligence period, And if it turns out the premium price for the homeowner's insurance would be a reason that the buyer would have to terminate the contract for affordability reasons, or because the lender would not allow a certain premium price for this homeowner's insurance and would deny a loan, then the buyer must terminate the contract prior to the expiration of the due diligence period or prior to the expiration of the financing contingency with the supporting loan denial letter in order to receive their earnest money back. What happened was the lender told the buyer after all the contingencies had expired, the lender would not allow the buyer to pay that. It was an outrageous premium amount. So it was a lender issue. And the buyer's like, it's not my fault. It's a lender issue. However, the buyer's financing contingency had ended. So that's the reason the buyer was trying to do it under other lawful reason, but that's why buyers need to stay on top of their lenders for everything before the end of those contingency timeframes. Anyway, therefore, regardless of the valid reason, buyer, it is a valid reason, I get it, but it had a time frame attached to it. Therefore, regardless of the valid reason, the buyers terminated the contract after the expiration of any contractual contingency timeframes to do so in order to receive the disbursement of the earnest money. Based on this reason, the buyer has defaulted by terminating this contract after the expiration of all contractual contingency timeframes to do so. Per paragraph C2A of purchase and sale agreement, as holder, the company will disperse the earnest money to the seller as liquidated damages for the buyer's default. Per paragraph B7D, parties agree to indemnify and hold holder harmless for performing our duties as holder with respect to the disbursement of the earnest money. Should the buyer and seller, there was talk that they were going to go back under, they got it worked out and they were going to go back under contract. So I knew that as holder from my discussions and research with both agents. Should buyer and seller reinstate the contract prior to the deadline to disperse the earnest money, then maximum one will keep the $6,000 earnest money on deposit until closing. Should the reinstated contract fail to close, the holder will disperse the earnest money as directed by written agreement by the parties, or will once again interpret the contract and disperse accordingly. So my point in using this one for this class is sometimes you have to go into a lot of explanation because this poor buyer is thinking, I had a valid reason. It wasn't me, it was the lender, but they were outside of their time frames. Here's one that's a little bit trickier. Again, the contact information. This one is 789 Abundance Avenue. Based on my interpretation of the contract and circumstances surrounding the termination of the purchase and sale, we're notifying the parties that holder will disperse earnest money in the amount of $5,300 to the sellers 10 days from the date of this notice. Please read. Contract, again, you start at the top and go through the contract with the dates and times and contingencies and what the buyer and seller agreed to in writing with signature. Contract had a binding agreement date of 12/21, closing date, blah, 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 is subject to two contingencies, a 7-day due diligence period. Don't just say 7 days. Tell them when it ends. Even agents get the timing wrong. The binding agreement date for counting purposes is day 0. A lot of people get that math wrong. So tell them when it ends. Ending at 11:59 on 12/17, and a 21-day financing contingency ending at 11:59 on 12/31. On 12/31, the buyer notified the sellers that they were terminating the contract based on financing contingency, which was acknowledged in writing by the sellers on 1/2. At 5/29 on 1/8/22, the buyer sent the sellers the loan denial letter from the Wells Fargo lender, which was dated 12/28. Per paragraph 5 of the conventional loan contingency exhibit B, the buyer had 7 days from the date of the notice of termination was sent to the seller to send the seller the loan denial letter from the lender. This time frame therefore ended at 11:59 p.m. on 1/7. and they sent it on 1/8. They sent they terminated within the contingency time frame, but they sent the proving loan denial letter a day late. Although the buyer terminated within the timeframes of the agreed upon financing contingency, Exhibit B, the buyer failed to comply with all of the terms of this termination by sending the loan denial letter within 7 days after the notice to terminate. Based on this reason, the earnest money will be dispersed to the sellers. And again, how you've sent them and objections in writing. That one was a tough one, but there is a lot of research again that goes on that has to happen on behalf of the holder. Now, I think this is the last one. Yep, this is the last one. This is if it's really complicated and you are going to interplead. I highly suggest brokers, you send a notice of your intent to interplead to give the parties the opportunity to negotiate between themselves before anybody is in a lawsuit, and attorneys get lots of money and nobody else wins. So this is 10, 11, 12 Prosperity Place. Again, same format. Again, you can use, and different brokers use different formats. I'm just suggesting this again for the reasons I've explained. Based on the expiration of the contract for the purchase and sale of blank address, and you guys, these are all real letters. As holder of the earnest money of $3,500, maximum one, Greater Atlanta Realtors, is compelled to interplead these trust funds into a court of competent jurisdiction, which was the Superior Court of DeKalb County, upon advice from legal counsel, in order that a judge may decide the disbursement. Brokers, if you have to interplead money, I highly suggest you do consult with an attorney before you have to potentially engage the public in a lawsuit. Determining factor. This contract has a binding agreement date of 3/28/24 and a closing date of 4/30/25. It was subject, you guys are seeing the format here. It was subject to 3 buyer contingencies, a 7-day due diligence period, thereby expiring at 11/59 on 4/4/25, a 10-day conventional financing contingency, thereby expiring 11/59 on 4/7, and a 15-day appraisal contingency, therefore expiring 11/59 on 4/12. The contract failed to close on 4/30. On 5/30, you guys, a whole month later, the buyer sent the notice of termination and proposed disbursement of earnest money, requesting that the earnest money be returned to him. The reason checked on this form for termination was due diligence, but the notice to terminate was not signed. Even had the notice of termination been signed, this contract had expired on 4/30. The seller did not sign agreeing that the holder would disburse the earnest money to the buyer. From communication with the buyer's agent and a copy of a text message sent to me by the seller's agent, it is clear that the seller did not have all the utilities, specifically the gas, on and operational as required of and agreed to by the seller per paragraph B8C of the purchase and sale agreement, which constitutes a clear seller breach of contract. The buyer did not have knowledge of this at the time of offer. So your agent went in and flipped the light switch on and ran the water. Those were working. They didn't turn on the gas, so they didn't realize the gas was not on. The buyer did not have knowledge of this at time of offer. Apparently, all of the utilities were on and operational at approximately 12/29 on 4/3/25. Upon consultation with an attorney, this did not cure the seller's breach due to the timing of all utilities being on and operational, because the buyer's due diligence period expired the following day. A negotiated 7-day due diligence period was reduced to 1 day based on this issue. The buyer was under the impression that this contract was no longer binding upon the parties due to the seller not having all the utilities on, and thereby preventing the buyer from being able to perform all of his options afforded him during the due diligence period, specifically having the property inspected. Although this quote, no contract was the buyer's assumption, the buyer failed to communicate with the seller his desire to rescind the contract based on the seller's breach, or to extend the due diligence time frame, or to terminate the contract. The buyer informed me that because he thought there was no longer a binding contract, that no further notices were required to be sent to the seller. Additionally, the property in the multiple listing services has always shown, so this is research I did as the holder, has always shown as active and never reflected that the seller was under a binding contract with this buyer. This fact communicates that perhaps the seller also assumed that this contract was no longer binding upon the parties. Regardless of any reason, this active MLS status definitely benefited the seller as being open to receive other offers from other buyers with no apparent backup contingencies or delays required by another buyer. Furthermore, the seller, remember this TNR came 30 days after it was supposed to have closed. The seller never initiated any contact with Maximum One Greater Atlanta Realtors as holder, requesting that the earnest money be dispersed to the seller as liquidated damages for any buyer default. This fact is also indicative that perhaps the seller also believed that this contract was no longer binding upon the parties. Only the buyer reached out over 30 days after the contracted closing date, asking how long it would take to get their earnest money returned to them, at which point the buyer did send the proposed release of earnest money to the seller to sign, agreeing to release the earnest money. As holder, I did consult an attorney on this matter. I have been advised that this issue calls for a legal judgment by a judge and a legal interpretation of the contract regarding the question if the seller's contractual breach is of a nature to warrant the forfeiture of earnest money by the buyer for failing to send any type of notice to the seller regarding the perceived status of the contract based on the seller's breach. Based on this need for a legal judgment, I intend to hire an attorney to interplead the $3,500 earnest money into a court of competent jurisdiction per paragraph B7C of the purchase and sale agreement. Per that same paragraph, I will also deduct my legal fees and court costs from this $3,500. Additionally, per this same paragraph, the prevailing defendant in this interpleader lawsuit shall be entitled to collect its attorney's fees, court costs amount deducted by holder to cover holder's cost expenses from the non-prevailing defendant. I will give the buyer and seller time to negotiate between themselves regarding the disbursement of the $3,500 in whole or in division between the buyer and seller, and direct Maximum One Greater Atlanta Realtors as holder how to disperse these funds in a written agreement signed by both parties. Should the parties fail to send me a signed written agreement negotiated between themselves, then on July 9th, 2025, I will engage an attorney to begin this interpleader action. So, couple of things. Number one, brokers and agents. A breach of contract, the remedy for every breach of contract is not the same. A breach of contract is not necessarily a default of contract. In this instance, the seller did fail to have all the utilities on and operational. That did constitute a breach, but not necessarily resulting in a buyer's ability to terminate and get the earnest money back. Even had that happened, the timeframes were all out of whack. It is reasonable to assume that both parties may have thought that the contract was terminated, but because now money's up for grabs, the seller's like, oh, well, I'm going to get it. So a couple things. Number one, a breach of contract does not always result in termination with rights to earnest money. Number two is you should always give them the opportunity to negotiate before having to go to court. I will let you know that in this particular instance, they did do a new agreement to release, and the seller did agree to give the buyer back the entire $3,500. So I am finished with the class. And just a couple of things I did show you where you can get our classes. CE credits will be recorded within 3 to 5 business days. Also, if I have a lot of friends and a lot of new people, I do have a YouTube channel called Real Estate Made Crystal Clear, and my target audience is all agents in Georgia, regardless of brokerage affiliation. I cover contract tips, license law tips, a ton of stuff in depth. And I welcome everyone to check out that channel. And I will let me know if you have any questions whatsoever. If you do need to go, again, please feel free to leave. We are done. I just need your name, license number, email address, and phone number one more time. If you do have any questions, I will stay on to answer questions, but with everybody typing everything in the chat, feel free to unmute yourself. I'll take any questions, any comments, any tips or tricks or hints I failed to mention. And I do hope that I achieved my goal, that the time went by very quickly. Apologize for the little snafu with the 9:30 and 10 miscommunication. I hope that you all learned something that you can use in your practice. And I do hope that you are ending this 3 hours in a better place than you came to begin with, and that God has used me to reflect his light to all of you. So thank you guys so much. Feel free to unmute yourself if you do have a question or a comment. And I thank you. I'm so honored by your time and attention. Thank you very much. All right. Thank you, everybody. If you are watching this online, I appreciate that. Remember, you do not get CE credit merely for watching this video. This is for informational purposes only. If you are watching this online, do welcome you to any of our classes, and I appreciate your time. Thank you so much. Bye.